Hello, and welcome to this podcast in the Collier-Bristow Employment Conversation Series. My name's Patrick Wheeler, and I head the Data Protection and IP team here. I'm joined by Patrick Kilgallon, an associate in the employment team, who is a specialist in the field of issues relating to artificial intelligence, which is the subject and topic for today's discussion. Morning, Patrick.
Morning, Patrick.
Right. So I suppose the most important preliminary question to ask is, can you just talk very briefly or just give us a very brief overview of what AI is or what it means, I should say?
So I think, as you say, preliminary starting point is definitely let's look at what AI means. So AI doesn't have a single agreed definition, but it can broadly be captured by the idea of making machines more intelligent. So it's the concept that machines could work in the same way as a human, but more efficiently and with better results. So whilst the end game is ultimately for artificial intelligence to act without human involvement, in creating an artificial intelligence system, there is often human input. You have to program the system to draw conclusions from the data, and to do that, there must be an analysis and understanding of human thought processes and how those thought processes precede action. Then you must look at, there must be a method of describing that analysis, using that method of describing the analysis to inform the instructions for the AI system. So often you have these human biases that can get coded into software systems. Now, at the core of AI is the algorithm, and this is the steps that the programmers have created that instruct the computer to use a data input and create the output. So often, the more inputs, the more data that is inputted into the system, the better the output is, as there is a greater comparison ability. So AI can be used over a variety of employment-related situations. It can be used to monitor employees. So you can generate, look at absences. You can have auto-generated ratings, instructions, work allocation, a whole variety of factors that AI can be used in. But as talked about briefly then, AI is really only as good as the data that it's been given.
Yes.
And this has the massive issue that data is not always neutral. And further than that, algorithms can often become so sophisticated that humans might not actually understand what's going on. For example, I think one of the issues, which I'll touch on a bit more later, is that there's lots of research at the moment suggesting that certain AI tools are actually less accurate with people with darker skin.
Thank you. I think that's very helpful so that we place what we discuss now in a bit more context. So what would you say are the key legal interactions?
Yep. So I think we've got a variety of legal interactions here that it's worthwhile employers being aware of. I think you have discrimination aspects, as just touched on briefly there, which I'll go into more detail on shortly. We have unfair decision-making from these AI systems. We have interactions with human rights, particularly the right to private life. And then also we have the data privacy and GDPR perspective, which we'll touch on at the end. So taking the first of those issues, the discrimination angle, under UK law, the Equality Act protects employees from discrimination on grounds of their protected characteristics. Now, these are there's 9 in total. We've got sex, race, age, disability, are just some other ones to mention. And this area of employment law was already displaying some tensions in relation to artificial intelligence. So as in March actually of this year, Uber came under fire for its use of facial recognition software after there was evidence that it wasn't actually being accurate with skin color. The lack of recognition of certain non-white faces resulted in Uber drivers being banned from the platform and losing their income streams. So obviously you can see that's quite a serious potential risk there. And this has further been demonstrated in America, where there was an example of an AI system that assisted judges in determining sentencing. However, there was an issue with the initial data set the system had been given. So this meant the AI program was twice as likely to falsely predict that black defendants would be repeat offenders. So it was almost as if the AI itself had become discriminatory. So you've got issues there with the technology itself not picking up facial recognition, but also the human error of inputting data. So under UK law, if that happens here, those errors I've just talked about would open up a discrimination claim for employees. If the AI system itself treats employees differently because of one of their protected characteristics, you have a good chance of creating a direct discrimination claim. employees in the UK are also protected from and against indirect discrimination. So this broadly means that any provision, criterion, or practice that's termed a PCP that puts in place a disadvantage on an employee because of their protected characteristic, anything that happens in that sense that puts a disadvantage on them is prevented under UK law. So as an AI system that's based mainly on an underlying algorithm, which is essentially a set of rules, that is likely going to be classified as a PCP and could, in theory, give rise to an indirect discrimination claim.
Yes, interesting. Just thinking as you were talking, I was wondering who might be liable here. I mean, clearly an employer who used the AI and presumably had some control over the data would be liable, or potentially liable. I just wondered whether the business that's responsible for writing the algorithm or inputting the data might also potentially be liable. I realise this is a bit of a curveball since we haven't discussed this, but is this something, has this given rise to any discussion that you know of?
I'm sure there'll be claims potentially between the employer and the AI service provider, but ultimately these employees would have a claim based on their employment relationship with their employer.
Okay. Sorry, I'll let you carry on.
Not so. So just on potentially some advice of how employers should be managing these aspects in relation to discrimination. The Trade Union Congress recently published a paper called the Worker Experience Report, which found that the implications of AI used in the workplace were quite unsurprisingly not fully understood by employees. And moreover, and more worryingly, employers who had purchased AI products and implemented them for their own business, they themselves often had little understanding of the implications. So it's just a flag that when employers are bringing in AI software from around the world, and particularly from America, where employment law is different and data protection law is different, they need to be careful when deploying these AI systems and when they don't understand how the software works. Otherwise, they do face the risk of relying on an imperfect system, which could result in discrimination claims. So that's briefly on the discrimination aspect. Now moving on to the risk of unfair decisions. So under UK law, for a decision to dismiss to be fair, it must fall within the range of reasonable responses. And this may have to be explained or justified by a human that has relied on the data created by AI. So due to artificial intelligence's complexity, the process resulting in this data can often be inaccessible. So if an employee is dismissed and they've not been informed of the data that has been used to come to the decision, or how that data has itself been weighted, it's quite likely to be an unfair dismissal. So AI, in this sense, can make decisions that impact incredibly directly on an employee's livelihoods. So often businesses use AI, as I touched on in the introduction, for performance reviews or disciplinary issues or dismissals. So a further consequence of the use of AI is that there could be a breach of the implied term of mutual trust and confidence. So if AI is used to dismiss an employee and an employer is unable to actually explain how the AI system came to its conclusion, whether that could be because it's too complex or because there's a black box issue, then there's quite likely to be a breach of that implied term of mutual trust and confidence. So a black box issue, that is a term that captures the inability of some AI software to explain the rules and logic followed in reaching its decisions. So, and employers are most likely going to be unable to hide behind that black box issue to justify an inadequate explanation in dismissing or disciplining an employee. So that's one to watch. And then the next issue that I'll touch on very briefly is the infringement on Article 8, the right to respect for private life. So as
the Human Rights Act, is it?
Yeah, yes, exactly. Yeah. So private space of employees is obviously being eroded. It's quite an intrusive process of getting into employees' data, keystrokes, or other forms of automatic software that can be used via the AI system. And that would fall within the Article 8 right to private life. So often you'd be able to capture this and explain it as a way that it's a legitimate aim. For example, checking employees are performing in a professional way. That's a legitimate aim of using AI software under the Article 8, respect to private life. However, there are limits to this, and it's important to consider whether achieving that aim, i.e., ensuring that employees are staying on task, you ought to ensure that's done in a proportionate way. Otherwise, you do risk breaching that right. So that's sort of a brief whistle-stop tour of the employment-related issues. So just wondering, Patrick, what issues are you seeing with artificial intelligence and how that is impacting on data privacy law and how that interacts with the GDPR?
Yes, well, thank you, Patrick. That was very, very interesting and a very helpful overview. From a GDPR perspective, people might be aware of a publicity surrounding Google DeepMind, which is an AI program that has been used to analyze health data. And they were given access to the data of over 1.6 million patients of the Royal Free Hospital in London to enable them to perform various analyses on that data, basically to try to improve health outcomes. But the issue was that there was automated decision-making, and the patients felt that they had not been properly informed of exactly what was going to happen to their data. So this gives rise to a number of questions. The issues for employers is, have employees been notified that their data is going to be processed using an AI program? Are they happy with this to happen? Do they understand what's going to happen? And this also leads into some guidance from the ICO, the Information Commissioner's Office. And they've published a paper. It's actually a few years old now, but it's still got some very interesting points coming out of it. And the ICO became increasingly concerned that the use of big data, AI, and machine learning had become so widespread that the effect on personal data, and in particular, as Patrick has mentioned, sometimes sensitive or special category personal data, which deals with issues like health, sex, religion, and so on. These issues really needed to be thought through very, very carefully before the program was employed and used. So just very briefly, what the ICO have done is to come up with a series of recommendations. And these are that any organization that wants to use AI should first give very careful consideration to whether data analytics, the ones they want to use, actually requires the processing of personal data. So can they achieve the objective they want to achieve without using personal data? Now, obviously, in many cases, that it's an absolute necessity to have the personal data. But in those circumstances, is it possible to anonymize the personal data so that if there were a breach, it would not be clear exactly whose data was being used and referred to before it's analyzed? The second recommendation is the importance of being transparent. So this is one of the key principles of the UK GDPR, transparency about the processing of personal data. And the way in which they can do that, they can use a combination of approaches in order to provide really meaningful privacy notices. So not just a notice they might have grabbed off the internet, but a privacy notice that actually explains what's going on. And this might need to be updated at various stages throughout an AI project. So in informing employees, they could have an intranet, for example, that could have icons, just-in-time notifications, layered privacy notices, so that you've got a question, you can go further down the list, click on a link. All of this is around making employees fully aware of exactly what's going on and how their data is going to be used. The next recommendation is that organizations should undertake privacy impact assessments. So this is an assessment which looks at the entirety of the project and works out exactly how personal data is going to be impacted at each stage. And in this way, it helps to identify privacy risks and assess the necessity and proportionality of any given project. And again, necessity and proportionality are key principles for UK GDPR. And in that privacy impact assessment, they're probably going to need to have input from all levels through management down to the most junior employees, so that everybody feels that they are engaged in and have some input into this assessment. In addition to that, all employers should approach any project like this with the principle of privacy by design. So this is, again, another key UK GDPR principle, and it involves implementing technical and organizational measures to address all matters relating to data security, to make sure that it's as safe against hacking as possible, data minimization, so that only the absolute bare minimum of personal data is used, and data segregation, again, so that it's not easy to identify exactly whose data refers to which individuals. And then the next recommendation is to develop ethical principles. So these should reinforce key data protection principles. And employees in smaller organizations can use these principles as a reference point when they're working on big data projects. And then the final recommendation is to implement innovative techniques to develop auditable machine learning algorithms. If you have your algorithm, you have to be able to interrogate it to make sure that the way in which it's operating and the way in which it's supplying the data it is not subject to bias wherever possible, and that you understand exactly how the data is being used. So both internal and external audits could be undertaken to try to work this out. So I think the overall message is that it's not something that you employ lightly. You have to give a lot of thought to the use of AI within any organization, its impact on employees, its impact on customers, its impact on suppliers. So there's a lot to be done, a lot to be thought about. And as always, Collier Bristow are here and we are very willing to help to provide advice and guidance on any of these aspects. Patrick, any other final thoughts before we close this session?
Yeah, just a few. So first of all, I think it's quite interesting that certain principles in the data privacy sphere, such as transparency, how they're also quite crucial in the employment law aspects. An example in the transparency in decision making and how that data has been used. So that's the first thing. Second is that AI, I think, ultimately going forward, it's going to develop more and more over the years, and it's going to become more and more important for businesses. However, it's just for employers to just be slightly cautious, as this technology does have wide implications. I think particularly employers should be aware that AI is not infallible, and it should be aware of some of the lack of transparency in its outcomes. So if employers do bring in AI systems to assist with decision making, they should make sure they have limits on how it's used, and also how the AI is used within the business is communicated to employees. So another finding of the TUC in their worker experience report showed the lack of consultation with employees where AI systems were implemented. So I think it's important in this situation that employers should be getting employees involved at quite an early stage in deciding how best to use AI within the business. And they should also enable employees to access sufficient information about how the AI system is being used, so they can be assured that it's being used in a lawful, proportionate and an accurate way.
Thank you, Patrick. Well, thank you to everybody who's listened through to the end of this podcast. There are others in the series, so please do have a look at the website and click on any others that you would find interesting. Thank you again for listening, and goodbye.